Could President Trump be charged with obstruction of justice? Were Comey's leaks totally illegal, as a Trump tweet this morning seems to ask? Those are just some of the legal issues raised by Thursday's riveting hearings. To answer them, we have Elizabath Foley, who teaches constitutional law at Florida International University, and Laurence Tribe is a professor of constitutional law at Harvard University. Larry Tribe, let me start with you. Alan Dershowitz has achieved some prominence recently by making the case that what Donald Trump did may have been politically deeply unwise, wrong, but it was not illegal or unconstitutional. You teach constitutional law at Harvard University. What is your judgment?
My judgment is that Alan Dershowitz is wrong. It's not even a close question. Of course, we don't have all the facts, but his position is the facts don't matter. The president simply cannot be guilty of obstructing justice because, as head of the executive branch, he can completely control any prosecution. The Supreme Court has twice rejected that view, unanimously in the Nixon case, by a vote of 8-1 in the Morrison case. The fact is that the president has all kinds of powers, but if he abuses them, for example, by accepting a bribe from Russia or any of a number of other things, if he does in a corrupt way, or with threats of the kind that he made to Comey about his retaining his job, if in either of those ways he interferes with the due administration of justice, that would be obstruction of justice, even under the federal criminal statutes of 18 U.S.C. Section 1503. But even more important, it would be an abuse of power that could be an impeachable offense. It's more serious than what Nixon did. It's really impossible to argue that no obstruction of justice could be present here. The facts, if they are as the very credible Jim Comey suggested, point powerfully to obstruction of justice and abuse of power, and the whole is greater than the sum of its parts if you look at all the facts. But I'll stop here. I know we have a limited time.
Professor Foley, what do you say to that? There are these two Supreme Court rulings that pretty clearly say, in the Nixon case and in the one that essentially established the independent counsel, that the president can't just do whatever he wants, even though he is the head of the executive branch.
Look, I tend to agree with Professor Dershowitz on the constitutional questions, but I look at this as a lawyer would look at it. I practice law in addition to teaching constitutional law, and there's a doctrine called the doctrine of constitutional avoidance, which means that the courts will first look to the applicable obstruction statutes, and if they can decide the question under the statutes, they won't reach the larger constitutional question. So let's look at those statutes. For example, Professor Tribe just cited 18 U.S.C. Section 1503. There are two different types of obstruction statutes. They deal with obstruction of investigations and obstructions of proceedings. One section, Section 1510, for example, deals with obstruction of criminal investigations. So you'd say to yourself, hey, this is a criminal investigation by the FBI. Maybe it's a violation of that statute. But no, you look at the statute requires an act of corruption, that is, it constitutes bribery, that prevents the communication of information about a crime to a criminal investigator. Even if you think there's an act of implicit bribery here, there's no impeding of a communication about a crime to a criminal investigator. So 1510 is off the table. And then you look at 1503, which Professor Tribe just cited, or maybe 1510 or 1512, all of which deal with obstruction of pending proceedings. The word proceeding is a legal term of art. It does not include an FBI investigation, and every single court that has looked at that question has said an FBI investigation is not a pending proceeding within the meaning of the obstruction statutes.
All right, let me get Larry Tribe in here, because we're on television and this might be getting too technical.
Well, I obviously don't agree. I don't agree. I'm a lawyer, too. I've read those statutes. 1503 isn't limited in the way that Elizabeth says, but there are bigger questions here. The broad question of abuse of power, to which she doesn't speak. I think clearly there's enough here for the Congress to go forward and for Mueller to go forward, as I think he is doing.
Professor Foley, let me ask you about another issue. Something that struck me during the hearings was the role of Jeff Sessions. Jim Comey seemed to suggest that the FBI already knew that the Attorney General was compromised, that he was going to have to recuse himself. Does it strike you as, I don't know what the right word would be, but a violation of his pledge to recuse himself from anything relating to Russia for Jeff Sessions to have then involved himself in the firing of Jim Comey, apparently over the Russia investigation?
Look, I don't know.
It certainly does.
I'd have to look
Are you
at...
asking?
Let's start with Professor Foley.
I'm sorry. Look, I don't know without knowing the parameters exactly of Jeff Sessions' recusal. I'd like to look at the language associated with that. But let me go back to the point about the obstruction statutes. Look, Fareed, your opening statement said that we need to care about process and the rule of law. If you care about process and the rule of law, and this is not just about the ends justifying the means and taking down a president that you don't like, then you need to care about what the statutes of obstruction say in this country. And I'm telling you that Section 1503 has been interpreted by every court to be limited to a pending judicial or quasi-judicial proceeding. An FBI investigation is not that. So there is simply no violation of any existing statute under the facts as we know it right now. If those facts on the ground change, I'll be the first one to concede that there may be an applicable pending charge. But to try to trump up an obstruction of justice statute is not respectful of the rule of law in this country.
I like the pun. Professor Summers, it's a political process, though. Impeachment by the House is not a purely legal process. But I want to ask you about a legal issue, which is perjury. If Donald Trump does agree to go through a sworn testimony, given his past statements where there have been many contradictions, is there a potential for him to perjure himself? I'm just thinking of the Clinton case, where eventually all that they could get him was perjury.
I think there's serious potential, and I must say, just being blunt about it, that perjury about a blowjob is not nearly as serious as perjury about Russian attack on our democracy. Talk about the end not justifying the means. It seems to me this is clearly a case where if you look at the Constitution, which you cannot avoid under some principle of avoidance, even if the statutes, as properly read, don't outlaw what Donald Trump did, there are a lot of things he can do that aren't covered by statutes, violating the Establishment Clause with his travel ban, violating the Emoluments Clause, as I think he did. So even if the statutes don't cover it, we have the broader question of whether the political process of impeachment should deal with a president who simply knows no limits of the sort that we need to preserve our constitutional republic.
All right, I noticed Professor Foley nodding slightly, so I will take that temporary moment of agreement as the moment where we have to stop. We will be back with both of you. This was a fascinating legal discussion. Thank you both.